Services candidate location Besigye and another information.
Lieutenant Uganda, Second Lieutenant Regime Nazareth, and I shall also be doing Second Lieutenant Arthur Phillips on board. Those are the items for the statement.
As you honorable chair, honorable members, my name is Amis Chakbala. I appear under the leadership of Senior Counsel Martha Wangari Nagua, together with Honorable Jeff Wako, Mr. Tukumi Moses, Ms. Kumihira Proscopia, Mr. Silas Kukur, Mr. Peter Nightway, Mr. Bayan Namkama, Mr. Tumusimi Patrol, Mr. Michael Chintu, Mr. Abubakar Sekanjako, Mr. Control Wilson, Mr. Mimbazi Elias Alcola, Mr. Kachipa Godfrey, Mr. Wanda Ronald Samuel, Mr. Frederick Panga, Mr. Katumba, Mr. Gabriel Lawrence, Mr. Julius Paul, Mr. Samuel Bigwa, Mr. Chizito Farouk, Mr. Enab Dennis, Mr. Moses Kabusu, and the other council who is not present is Mr. Kiza Ero, is still council for Honorable Chair, we have some housekeeping issues that we need to deal with before we the Chair allows. Handled by my starting off with the council. I believe it is
the court. One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspect in the law. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Aaron Chisa was denied access and it resulted in him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. The judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my people has come with the photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are settled for a particular purpose. That's what tribunal means. And therefore, I will plead with the judge advocate, please let us give the proper terminology, proper interpretation because they're bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English.
For me, if I may interject, the one what is defined in the UPDF Act, we are not going to adapt the dictionary definition. Use the UPDF Act to define what is the meaning of code. And that is the one we shall go with.
That exactly is our problem.
Which was enacted by the environment.
It is true.
So I would say that unless you go back and start it from
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and the meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article invite you to check the word tribunal so that we do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman has wanted to substantiate his issues with prayers. Number one, Mr. Chairman, issues raised by Senior Counsel quite fundamental in the administration of justice before you, or by this court-martial. From the list read by my friend here, Council Kalibala, the name Yaron Chiza remains on the list as one of the advocates representing their chosen parcels. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the regime, despite what transpired the last time we appeared here, the proceedings of the Southern Court. Mr. Chairman, we're wondering whether there will be orders, but by the time the proceedings come, you have discretionary powers to be produced here to execute the duties, and then maybe his return. But we leave it to you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches the right of fair hearing, initially in Article 28 of the Constitution. And as we indicated earlier, it's a specific role he had been assigned in representing their chosen persons. So we beg to be guided, Mr. Chairman, in how Aaron Chiza is going to continue featuring in these proceedings as one of counsel. And we ask that you pronounce yourself on this particular matter. Two, again, we ask Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1, the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused officers all over, manning the courtroom here, manning the premises, handling all these protocols here with the environment. And finally, Mr. Chairman, on the nomenclature, turning out to be controversial. The issue, I thought they wouldn't be fast about it. Because we use these terms interchangeably, even in the course of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal addressing you as your lordship. Saying, my lord, my lord. Yet, first we are addressing you as a chairman. Would that also be taken to be undermining this court? That we are not addressing you as my lord? That we are addressing you as a chairman? And if the judge, advocate, and the entire panel shouldn't take offense about this, we can interchangeably refer to you as a court, we can interchangeably refer to you as court martials or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature, and that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, fundamental, and the dispensation, in regards to the dispensation of justice. I beg to move this.
My name is Samuel. Mr. Chairman, I raise on two issues. First, whereas inside a better conducive environment this morning, the same was extended outside. Some of us have to walk the kilometer to court. Right from the T-junction, we are faced with the blockades. I don't know why council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we are being pushed to park? I think this should be addressed. We've seen a large parking space up here, in the premises here, so that should be handled, Mr. Chairman. Secondly, are we truly constituted as a court in the absence of reserve members of the court martial? We need to be guided on this issue too. Right. Mr. Chairman, short one, regarding what colleagues have said, vis-a-vis using the word interchangeable terminology. It's a German in our constitution, Article 151, which is at page 130. And this touches on courts. Or forum. It's not necessarily underlying court. It is just what it's not necessarily underlying court. It is just what administration. And kindly request that that's the only line.
Summarize this. We start from the bottom. Council member. This is what council member said. By the time I came, I did not even see anybody in the room. So I can't tell unless I have to consult people who are managing the security. But on that one, I can't tell much about that because by the time I passed there, there was nothing. But if I'm not mistaken,
is the volume back? You let me know because it is about the network. It is not about the volume putting it down.
Much as you want to bring us in almost all issues, I think somehow some of you need to bring yourselves. Council Bravo, you have been talking everywhere what you are intending to do. And I think they cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, I can't tell. But I believe could have managed maybe from those settlements sometimes to make. And on Council Aaron, I don't know really what you are pushing because I've never had, unless JP will guide us also on that one. The person who is serving the sentence to come and attend the court that can be advised on that. Senior class, I don't know, you said, I don't know where this one came from. You know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one where it came from. But I think even the villager wants to serve from Kenya or Tanzania. It's good you have talked about the context today, and you remember it was raised the other time, and you said I'm going to talk to these people. And that's what we want. We are not here just to, it's not a war.
And I don't know why you are looking at one side, you are not looking at the other side. People making noise in the court. To the extent of even of standing on the chairs which they are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere at once. The council or anybody submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where confusion comes from if we are following what we are supposed to. Unless if you have, especially the council was asking about my vote versus chairman, and then the reserve members.
Sir, I will take the opportunity to respond to the legal issues arising from the submission of defense lawyers. And I also refer them to carefully regulations 63, which talks about the duties of the judge advocate. Regulation 1 says that the prosecutor and the accused respectively are at all times after the judge advocate is named to act at the trial entitled his opinion on any question of law or procedure relative to the charge of trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, calling this court a tribunal, that one will not happen. The UPDF Act defines court-martial as field court-martial, general court-martial, or court-martial court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintendent over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Aaron Chiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Sub-Clause D. Sometimes I never to read because when I refer to read, they say I should read. So I will read. It says every person who is, right, that's the right to fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, right of the offense, you cannot say that when we have 30 lawyers here, Aaron Chiza, who was convicted by this court, is not there and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted is not there and all over 30 lawyers are here, that the right to doctor is violated. My answer is no, and if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but say you can be 30 and Chaser has a specific law. To me, that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter is able submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Kwabo, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in reserve, were present, and all of the members before you have been following this case, have been reported. So the fact that you are seeing one is not there, whoever is there has been here from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notes. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Banga, I will not go into it because I have already given my position. But Senior Council Karua say that me, as a Brigadier Tukachumi, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you to apologize for saying I said you called me a foreigner. We have interacted, but it has never come out of my mouth. That is my response.
Yeah, Mr. Chairman, remind my other friend here that it is actually on video. You refer to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
Your court members, we are ready to proceed. This case was that issue is not disclosure of problems. Which court has not pronounced itself on? There is no prior at all regarding the proceedings where the ban has been shifted.
That's what you were talking about. That's what
It's advertising the court. It's not that it's not. He was advertising to JSFC.
This is alleging that they have changed. Can he say more?
It's like this council of members of this court.
But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenge the decision of that court. But you cannot raise it here that court is going to pronounce itself. Court was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a continuation appeal court. Appeal with proof. They will give you an answer.
Therefore, kindly give us a list of those who sat at the sentencing session for Aaron Chisa, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there's also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Uganda Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government. Only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Chisa when he is in court as an advocate. And the issue was the success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like to refer and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought you responded.
You asked us to refer us of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what I think is referring to, Madam Chairman, I think she will need to address herself on the procedure, especially on references under our rules, Constitutional Court petition and defense rules. And I don't think by submitting that she's seeking a reference to this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, Madam Chairman, I pray that we proceed with what the merits of the case are, instead of going against what the rules of reference provide.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you open again. The question of jurisdiction was the first thing we dealt with when before I took even the plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg we proceed with the chair. Maybe Council was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that called me my lord. You can call him honorable chair of the court. It's okay. So I don't think even the question was asking you. that can he respond? There's nothing to respond there.
Mr. Chairman, just before my senior colleague starts, again, just for consistency, we kindly request.
Also, let's not repeat what have been said and answered.
I'm not going to repeat, Mr. Chairman.
Yes.
I'm only asking that because we are many, if we could kindly follow a process whereby if the matter is raised before the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my Lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. It appears then that the judge advocate is either coming into the realm of the state and also taking over the role of court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to an agreement. It would be unfair to Mr. Karibala, for example, if he read his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Kawa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, but at the last sitting, your neighbor to my right exactly was not on the panel. I don't know why any particular member here identified only her. I don't know, but they insisted that she was not on the panel. Other members before have said that there was one lady. Now there are two. I think that causes a concern, and it may go back. So it is an issue that if we break the consistency of the panel which constitutes the court, then the judge will advise that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for their persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, and it is good that they are here, so that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a small center so that we are happy and they are there to see them and they are sort out. So I request, Mr. Chair, before and maybe we first state the issue of the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision hears us out. It's our Mr. Chairman.
Mr. Chairman, on the same, my whisper was not voted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was the observation. And it's clarified. Secondly, I think my issue of parking includes access, my access.
There is an advocate with who is
I'll not come back to this court if I'm parking 1 kilometer away. Access includes the parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as council. Like his persons. I'll not carry a box of books like I did today, 1 kilometer away from here, Mr. Chair.
I'm sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They alleged it is a name of Kalebo, and the collar was red. So we don't know whether so we don't know whether the person today has lost the red card. But my Lord, as you can see, it's the concern that the people here in Besigye, when they are changing, there is a concern that may not be had fair and square. It's our direct request, Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the panel constituting the court. I'm sorry, of the panel constituting this court.
It's all right, Council. Yes, the other day there was a panel here, as you have said, but as you heard from Judge Advocate, we are 19 members. 27 are supposed to be here, including me, and then the reserve is supposed to be behind there, so that's 7. But maybe some could have misplaced by a few.
There are few.
You can see it's that when the case one maybe have a problem of fields, you can go out and another one can. That's how we usually operate. Unless we add on something, but that's how we operate. Then the accessing the court. Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And
I think so what I can inform the lawyers is that this part of the court is composed of 7 members before it can conduct business on any case of a capital nature. We have 7. There is now no case arising before this court where Mr. Sara was not present. So we are ready for today's exercise.
Mr. Chairman, we need to put this in the context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused person is at liberty to say so. So if the panel keeps changing, like we have told Captain Okaleko Sleep, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That have not had the pronouncement of the court martial, the validity of the proceedings, because it was not done on the day. Actually, Aaron Chiza was summarily tried and convicted when Captain Okaleko came in. Kano Okaleko came in. When Kano Okaleko came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the party that is going to try you. So this is the whole point we are making, Mr. Chairman. So if, Mr. Chairman, we continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself. Which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need reinforcing the submission of my grand friend Freddy Park. Let the court make a pronouncement, a decision.
Counsel, the culture here is once a chosen person is brought to the dock for the first time, he's introduced to all members here and remembers which was done on that day. So this or changing of position or operation just is when we are proceeding. Or maybe unless you are asking that when is your Karibu now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced because Captain Kano Okai was never introduced to the person. This is the point. All the accused persons. This one's in the dock and the other is because he was also put in the dock as brief. So Okalibo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. And they are asked, and they answered. They had no objection.
I'm sorry about the volume. I'm sorry about the volume. It is only.
You cannot say that Chiza was supposed to take a plea. He was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
But I think you need to cross the chapter of Chiza because he was convicted and sentenced. If you are not satisfied, you know what to do. That one. I think
He's still on the part of the lawyers.
So should we adjourn up to his fictitious sentence?
It's the guidance we are seeking from Mr. Chairman. How do we deal with this?
About the convict, the one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which means all of you cannot proceed.
I think it is very important what the judge advocate is giving as advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are expected to side with the judge advocate, or for good reason to differ with him. because we are objecting also based on law, so that you're given the correct procedure. What happened to Aaron Pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think so. We need to move forward, Mr. Chairman, and we close the chapter. All matters are
No, we are closing the chapter, but what I want to tell the first attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are very responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me a light observation, Mr. Chairman. On the issue, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, well, when at the ruling which resulted in street sentencing, my land friend Aaron Chiza was being read, reference Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Chiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So I think you need to give them the other instrument of power so that they understand the conclusion of this code.
Remember what? We have our one in this there, and they are also advocates. They are there, they are sitting, don't just sit, they are clerks. The major and the one next, they are also advocates. They manage our registry, it is also under my office. So you can ask anything, if it is an instrument of appointment, we have it.
Go ahead, go over to this state.
Mr. Chairman, just the last one, the very last one. It touches me personally. Mr. Chairman, it touches me. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, your indulgence, Mr. Chairman, I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I be permitted, Mr. Chairman. Mr. Chairman, I beg.
I think some lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman. It's a humble, as you know, and
This is what we are saying now. Because if you are to conduct ourselves like that, then we don't go anywhere.
because, Mr. Chairman, we are dealing with matters of life and
Since we started, we are talking. Now let's say.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is dead.
Chairman,
The charges is dead.
I suggest you rail on council for a vote to respect the chair and vote. Lawyers cannot speak at the same time when you are not standing. It's better list.
Council Raphael proceed.
on the 7th of January, when this matter came before this court, I concluded this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending this charge sheet pursuant to Regulation 66 of Uganda People's Defense Forces Code of Procedure.
on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of the investigations, some facts were revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is Article 12743, Captain Dennis Ora. The adult Ugandan, a soldier of regular forces of Uganda for the defense forces. And he is attached to Command Brigade.
Sorry, this is part of the particulars of the
So it is an article 74.3 of the Genesis Ora. It's an officer attached to Ahmad Brigade. And we are also adding there the public of treachery, which will be housed too, including the officer and the two accused persons. Those are the amendments we seek. Wow.
Mr. Chairman, we object to the amendment, especially before the ruling of jurisdiction. In fact, we stopped the application for reference to await the ruling of jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. So the court has no, it's in our view that the court has no jurisdiction on these two gentlemen. And we seek that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure.
Council, which ruling are you talking about? Ruling are you talking about?
On the ruling that you referred to Mr. Ukwago having on your jurisdiction file. There is a ruling you've been seeking to deliver ever since we came
From the Supreme Court?
from yourselves, from this court martial.
That's what was given first.
Not the ruling. If from the jurisdiction, there is a ruling which was delivered on the same day it took place.
that ruling relates to matters that were raised the first time the accused persons were charged. That matter has something to do with jurisdiction, it has something to do with the extraterritoriality of some of the offences or how we got here, and therefore it's right to charges. So we have all along been under the impression that we need this temporary. I do recall my land trade profile once actually rose and said we are ready to proceed. But the events that have taken place since last time have not been that. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, it relates to what the Ugandan has just prayed about the amendment charges. I am looking at the rule that is cited, and it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributed to a clerical error or omission. And he did say that in the charge there are reference to some officer. I haven't seen that reference myself in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. You must have known the name, but just refused. So I'm not sure that regulation 66 allows him to do what he's asking, than to join So I just rise on those two issues. Ruling what that is.
Mr. Chairman, for the record, I'm Louis Bazinamukol. I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to the attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwabo, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving the ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeating.
Mr. Chair, just for recollection, maybe recalls when senior colleagues first year raised application for an adjournment for an hour, and court wasn't ready. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver the ruling regarding matters raised by Mr. Elias Lukwabo. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Keys. So it is correct, if I recall, that it was at my request that we are granting an adjournment of 15 minutes so that we come back and issue the ruling of the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm that it is correct that there is a pending ruling.
Council understand what the regulation 66 1 that we will proceed to paragraph 2, which states at any time during at which there is a judgment, it appears to the court before it closes its finding that it is desirable in the interest of justice to make any addition or omission. So that is the idea. I'm moving so-called addition by addition because this is during the course of the investigation. Additional evidence was got and the person is added, and also another count is also added. In regard to the ruling, we are also expecting the ruling.
Just a brief between Rule 66. I had read this as Rule 2, but my interpretation of some Rule 2 suggested that it only applies when we are at a stage where the court is closing the deliberation is finding. We are still at the initial stages of this matter. So I still submit that either to the judge to proceed under this Rule 66. 66.1 doesn't help him. 66 certainly destroys his
Allow me, Mr. Chairman, to add just one thing.
My lord, they have no locus.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66, 1 and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court of the area.
The court is adjourned for 10 minutes.
Okay, the court is adjourned for 10 minutes and we are taking a break of Besigye yawubira abantu Davis. Alright. Court has taken a break of 10 minutes. We are coming back in 10 minutes. Still to has taken 10 minutes for a break. See how they can come around. See how come around. As you see everything here.
Kasozi. Olina Newton.
Wali wano.
Yanga ndio akosa simu yangu bangi kuba kadi jiweko.
Wanje?
Newton.
Mukuwe.
Yawan.
Gambe.
Sabugwao. Musajja wange mulete tosobola.
Nenda mlive ya mawulire kati. Kasozi.
Wanje.
Mungambire ko live ngena moya wano wabwepi. Bako cha omudde dakika 10. Mambo cheche shininga bulala. No. Hata nzeka kopea kuba. Kufango la bichongo itanse cholita bicho bare tanga. Actually, the best one pump.
I wasn't talking, man. Okay, but not in your van.
Yeah, no worries.
Also a minute aneno briefly abena tubulirako tuwumuddemu eddakiika 10 chairman asabye kooti ewumulemu eddakiika 10 nsonga kitulabye nga Kano Kizza Besigye ne munno Obedi Lutale waliwo omusirikale abo yegasseeko munda ayinza okuba nti agambibwa nti oba alina akakwate ke yateeka. Yes, tulambululiremukko n'abatulaba wano.
Kakati olwaleero tuli wano General Court Marshal era tufunyemuko katono naye ekireese ekyo kiyamaani wa kooti awummuzaamu kooti eddakiika 10 nga ekireese kino ku mulundi ogwasooka omulundi gwe twasembayo okubeera wano bagezaako nnyo okwagala kooti ekole ruling gye twali tulinza okumala ekiseera naye bo bennyini olwaleero batwewunyisizza ate nga chairman wa kooti agamba nti takimanyiiko nti kooti eno erina ruling gyeterina okuwa naye omuwabuzi w'ekkooti yamanyiddwa nga judge advocate amutegeezezza nti owekitiibwa chairman w'ekkooti waliwo ruling gye tulinda era eteekwa okuweebwa ne ku mulundi guli twali tulina okugiwa ekyo nakisapootingibwa ne omuwabi wa kooti eno mwami omusirikale naye n'ategeeza kooti nti ekyamazima waliwo ruling gye tulinda ekintu chairman wa kooti kyagamba nti ye abadde takimanyi ate nga ku mulundi guli ye kennyini yagamba nti ruling weeri erirwe tugenda giderivalinga oba Martha Karua tannaba kufuna practicing certificate ye tugenda kubawa ruling naye olwaleero munnange kirabise nga ruling erabika ng'eteriiwo complete so ekyo kireetedde omulamuzi okugetinga confused oba chairperson ne judge advocate nga tebali ku page eno bwatyo chairman wa kooti mwami Freeman n'agamba nti kooti kewummulemu eddakiika 10 ndowooza bamale okwetereeza bekakase oba ruling weeri oba teriwo naye nga ruling weeri era tugirinze okugituwa ekyokubiri tulina ekintu ekipya kyetusanze mu kooti olwaleero omukulu chairman wa kooti ategeezeddwa omuwaabi wa gavumenti nti balina bo nga aba gavumenti munnamagye omulala akola ne Amadi Brigade bamuyita Ola Dennis Ola gwe baagala okwongerako ku musango gwa Dr. Kiza Besigye ne Obedi Lutale nti era naye okusinziira ku kunoonyereza kwabwe yasangiddwa nga y'omu ku bavunaanibwa abalina okuteekebwa ku musango guno so n'olwekyo nga basaba ekkooti nti tegenda mu maaso na kuwuliriza musango guno oba esooka eyimirize okugenda mu maaso n'omusango bamale okukyusaako mu mpaaba yaabwe bayongereko omwami oyo ekintu ffenno kyetuwakanyiza ddala kubanga ffe tulowooza nti ekyo kikyamu era kigendereddwamu kulemesa chairman wa kooti ne kooti ye okutuwa ruling olwaleero n'olwekyo ffe bwe tugenza okukebera amateeka gennyini gayagala okuyitiramu okukyusakyusa mu mpaaba yaabwe okwongerako omuntu omulala mwana wange tegamukkiriza ate kwongerako omuntu omulala yenna mu stage gye tuliko tusomye rules ezo era ne tutegeeza kooti nti amateeka gennyini omuwabi wa gavumenti gabuulidde kooti ate tegamukkiriza ku addinga okukola kye tuyita amendment to the charge sheet mu kiseera kino so chairman wa n'awummuzaamu kooti eddakiika 10 ne tufuluma kati tulinza ate kuddayo.
Briefly in English, some people are watching you from California and the outside of the country.
Yeah, so I was saying that today we are back here at the General Court Martial. However, right now the chairman of the Court Martial, Mr. Freeman, has told the court that he needs to adjourn the court for 10 minutes to have a break and they deliberate on issues they want to deliberate on. But preceding that, in court, they informed us that they intend to amend the charge sheet. They intend to amend the charge sheet to add on another serving officer of the UPDF under the names of John Ola. That John Ola is a UPDF serving officer who works with the Armored Brigade. They are saying that they intend to amend the charge sheet to add him on the charge sheet. Something we are saying is wrong according to the law. The prosecutor has provided the laws to the court that allow him to amend the charge. However, when we read the same laws he quoted to court, we realized that the laws do not permit him to amend or add another party at this stage. So there was an argument forth and back in court. That is one limb of it. Then, as we were still in court, it happened that the judge advocate did not remember that we were waiting for a ruling. It is clear that last time we were fighting a battle between them, not wanting us to wait for the ruling, and they wanted to deliver the ruling. On that day, the prosecutors were fighting hard to ensure that the ruling is delivered. Today, the judge is not aware that he's supposed to deliver a ruling. Mr. Freeman, the chairperson of the court, is not aware that he's supposed to deliver a ruling. But it is on record that himself last time, he said that even if counsel Keron Kiza has been convicted, Martha Karua had not secured her practicing certificate, the court was ready to deliver a ruling. However, today, the chairperson has surprised us by saying that there is no pending ruling to be delivered. The judge advocate advised him that, sir, there is a pending ruling. He still didn't believe the judge advocate. The prosecutor said the same thing, that there is a pending ruling, Mr. Chairperson. That's when he said that right now I am adjourning the court for 10 minutes. Probably we are presuming that they are going to consult and come back with one position. So we are now in the 10 minutes he has given and waiting for what is happening and to be called back to court.
Thank you very much, Counsel. Tell us the position you are coming at, probably in your constituency.
Yeah, I am coming. I just want to inform the general public and Ugandans generally, but specifically the people of Katikamu South constituency, that I am your next member of parliament for Katikamu South. I am coming to stand as a member of parliament for Katikamu South constituency. The abuse of human rights in this country requires a freedom fighter, requires a human rights fighter. So in Katikamu South constituency, we can no longer have incompetent people representing us in parliament. So I'm requesting that the Ugandans in Katikamu South constituency consider me because I'm the best candidate so far. That is the position. I'm going to parliament.
You give it us in Uganda.
Yeah. Njagala kutegeeza bana Uganda bonna okutwaliza awamu naddala abo abali mu Katikamu South constituency Luweero nze munnamateeka wamu